In my youth, before I became a dean, I was played at a scholarship in the field of Indian law, which is why I met Phil Frickey. And others have talked about Frickey jurisprudence. And of course, we've also heard of Frickeyville, which is that magical place where we all live together. Among other things, I thought I would talk about Frickenomics. Frickenomics is, of course, naturally, the way in which the wealth of the world has been increased measurably by the way that Phil has enriched all of his friends in so many ways. Like many of you, I met Phil when I got the phone call. Because this is a guy who cold calls. You know, he reads something you wrote, he thinks it's pretty good, he picks up the phone and he calls you. And I had written something that he had read, and he was relatively new into teaching, I think, Phil. And he called me up and introduced himself and said he enjoyed reading something that I had done. Talked a little bit about himself, and said, "So what do you think of the state of scholarship in Indian law? You know, there are a couple good people out there. Goldberg, Ambrose seems pretty good, and there are a couple other folks who are pretty good out there, but gee, it seems to me that there's not much going on in Indian law." I'm going, oh my God, a kindred spirit here. Indian law scholarship, much of it, not of course all of it, was acontextual, ahistorical, formalistic. In fact, the reason I think many of my students used to misspell canons with two N's, I'm sure this has never happened to you, was I think, especially in Indian law, the notion of the canons was so sort of decontextualized from any normative underpinnings that people just thought that they were something you'd come in and recite, you know, like you light the fuse, boom, you say your canon, you win the case. And there was a lot of that in Indian law, the sort of magic words theories of the so-called Indian canons of construction. People like to talk about them a lot, but they never seem to deal very much with the structural, normative, and other underpinnings, why we should have canons, how they function, everything else. And the other thing about Indian law at that time was nobody talked about race when they talked about Indian law. That didn't seem to be something that Indians are a racial minority, among other things. They are, regard themselves as separate nations and have a whole different structure. But there is an issue, if you look at jurisprudence in American Indian law, that the kinds of very casual racist statements that nobody would be using about other groups were still being used about Native Americans in the 1950s. So I had found a friend, and I think I don't know how many times we talked on the phone before we finally met. I talked him into going to the Federal Indian Bar Conference, and Phil just became this person that I could pick up the phone and call. And so many of us in those days in the field of American Indian law, we were, well, of course, we're still the only one at our school usually, but with some exceptions, Carol. But we felt very isolated. God hadn't invented the internet yet, or no, I guess it was Al who invented the internet. And we were much more atomized. It was very, very difficult for us, and we felt very marginalized. So it was just great. And Phil's ability, well, you ought to meet this person and I read something by this person. It's really good. Have you read that yet? You really ought to look at it. Or if he wanted to write something critical, he'd say, I really want to criticize this guy, where he's coming from in Indian law. I just think he's so deeply wrong, but do you think I got the tone right? I don't want him to get all defensive, and I'm speaking of Phil. I don't want him to get all defensive and angry, but I want to try to make the point, and it's just so brilliant the way that Phil knits us all together. Whether or not it's in the field of Indian law or with me, it became, with law school, with classmates, with teaching constitutional law, which I also taught. He introduced me to Phil Eskridge. And by the way, don't make me follow Phil Eskridge again. I mean, really, it's just not fair. And then Palmersheim reads a poem. Who can follow either one of those things? It's a terrible thing to do. My whole panel is sitting here trembling. They can't believe it. Phil is a networker supreme. And a friend, a very dear friend. I went through a very tough patch in my personal life, and Phil, I could call him and talk about it, and he was so understanding and so great. He's just that kind of guy. And the mentoring that he would do, he sort of treated me as if I were already launched, right? But he taught me an awful lot. But the young people coming into Indian law, he was so interested in identifying who's out there, who's promising, who can we really bring along, what are some mechanisms by which we can encourage folks, and a whole new group of young scholars in Indian law have been fostered by Phil, reaching out again, making that call. Hi, I'm Phil Frickey. I read your article. It's really good. Let's talk about it. And they are indeed on this panel today. We have Phil's sort of legacy panel here. So we have a new generation of scholars who are empirical, contextual, pragmatic, just contributing so much to the field of Indian law, and that's because of Phil. And I think that the essence of Frickenomics, if I had to put it in one word, hard to do, that would be love. And Phil, your love has meant so much to us, and we love you very much. Thank you. So our panel is made up of three outstanding young, well, are you still young guys? You've all got tenure and everything now. Compared to us, they're young, right? And I will just mention them all, and then they'll go one-on-one. First, Bob Anderson, the director of the Native American Law Center and associate professor of law at the University of Washington School of Law. Bob will go first, and after him, Bethany Berger, who's a professor of law at the University of Connecticut School of Law, and Oneida Indian Nation, a visiting professor at Harvard this year. And then finally, Sarah Krakoff, an associate professor of law at the University of Colorado Law School. And we are going to go strictly alphabetical order, so Bob, take it away.
Thank you, Nell, and thank you, Phil and Bolt Hall and Dan Farber and the organizers of this wonderful event here. It's really an honor to be here, and as Nell mentioned, I'm going first because my last name starts with an A, which is sometimes good. It's also the reason why my name appears first on our casebook, and as Nell mentioned, that casebook in American Indian law started with a phone call from Phil that said we ought to do this book, and we sat down, and next thing I knew we were having a meeting in some courtyard out here, and Phil had we had gone over the concepts over the internet a little bit and email and talked on the phone, and we sort of thought about how we would do this, and we came out here, and Phil said, well, he pulls out from his briefcase a sheaf of papers. He says, well, I've done a run-through of a few chapters here. And there they were, the meat of the book. And I was shocked and amazed, and just honored that Phil would have asked me to be on a book with him along with the others. And Phil and I had something else in common, which was I graduated from the University of Minnesota Law School, unfortunately, just before Phil got there. And so we missed one another. But as I was practicing law for about 18 years before I came to academia, I was constantly trying to use the scholarship of Carol Goldberg and Nell Newton and other colleagues to help me in my cases. And it was very helpful, for a while in the 80s it was even successful, at least through the Ninth Circuit. Unfortunately, things changed after the early 90s, but then I discovered Phil Frickey's analysis. And, it was, gave a tremendous boost, I think, to all of us in the practicing Indian law community or in government, where I was in the late 90s, to have someone who was a respected scholar in constitutional law, in legislation, come into what we considered our field. There's a very small corner of the world that constitutes Indian law, and to have someone of Phil's stature embrace it was just gave us a tremendous boost in terms of how we felt about our legal theories and justice and doing the right thing. And while the Supreme Court has not improved in terms of Indian law jurisprudence, Phil's ideas have had a tremendous effect in terms of how lawyers approach problems in the Indian law area. And I'm going to use my few minutes here this afternoon to talk about Indian water rights and to point out how Phil's recommendations regarding and I'm quoting him here, the idea that we need bottom-up consequential calculus rather than top-down consistency with abstract doctrine. I take that to mean identification of what problems are on the ground within Indian country and between American Indians and their neighbors, and figuring out how to resolve these problems, sometimes through litigation, but more and more often through legislation. And the water rights arena provides the greatest example of that, I think, that we have. And I think it's going to be even more important as we move forward and face additional problems with water supply based upon climate change and increasing demands on limited water supplies in the West. But before I go there, I want to read one of my favorite quotes from Phil, and it was so heartening when I read this the first time. Out of the Minnesota Law Review in 1996, that to hear someone of Phil's stature say these words in the Law Review, the involuntary displacement of indigenous peoples from their lands and their political subjugation by a self-proclaimed superior sovereignty is ironic. Indeed, in a country that began by declaring itself independent of colonial status and that soon adopted a constitution that has served as a model for restraining the abuse of public power. In both law and life, things are a good deal more complicated, both descriptively and normatively, than grade school history classes, high school civics classes, and law school constitutional classes suggest. And Phil goes on in the article to explain the anomalies and problems with the way that Indian tribes, their territories, and Indian law had been ignored and marginalized over the years. And I think Phil's work has sort of brought Indian law out of the dark corners, the arcane, complex area that it remains arcane and complex, but I think Phil has brought it into the light of day more than anybody else in the modern era, and I thank him for providing that to us. Now, with that little backdrop, let's just talk for a second about Indian water rights. And now I was thinking on my flight down here, how am I going to talk for 15 minutes? I'm sure to be nervous in front of all of these tremendous scholars, and now I'm going to ask Nell to make sure she keeps me on time. But when you think about the place of Indian nations in the United States and their property rights and their reserved rights and the role of the Supreme Court in adjudicating these issues, I always like to start out with the case of United States versus Winans, which involved the typical scenario where an Indian tribe in a western state was confronted by the United States executive branch, encouraged, if not forced, to negotiate a treaty. The tribal leaders negotiate a treaty. They cede and relinquish most of their aboriginal lands to the United States in exchange for a small parcel of land, a reservation, if you will, of land. In exchange as well, they reserve a right to fish at usual and accustomed stations along the Columbia River. That's what the treaty says. Well, what happens when property along that river is deeded to a private party, in this case, the Winans brothers? Well, the Winans brothers have a patent from the United States. It says nothing about any easements across their property, nothing about Indian fishing rights, and the Winans brothers bar Indians from traveling across the private property to get to a usual and accustomed place that was reserved in the treaty. They fish in the river to the extent that they block fish from getting upstream. What about that? Well, in 1905, the U.S. Supreme Court said, well, that treaty is the supreme law of the land. The tribes agreed to cede their land, and in exchange, they reserved a right to fish. There must be an easement implied, sounds like property law, to get to that usual and accustomed place. Easy answer. Secondly, what about these people that are blocking the fish from getting to the tribal fishing site? They can't do it. Federal supremacy precludes the interference of private parties with that federally protected right. It's supremacy clause, it's property law, and perfectly reasonable case that stands to this day. 3 years later, another case involving an Indian reservation in an arid part of Montana. Tribe has agreed again to cede the vast majority of its land in exchange for a small reservation in order to convert the Indians on that reservation into farmers. Turns out that the non-Indians developed the water resources first, and there's not sufficient water for the Indian tribes. Well, what about that? The Supreme Court in Winters versus United States holds that the waters were reserved, at least at the time of the treaty, to provide for a tribal homeland, to fulfill the purposes of the reservation, and that those rights, although unexercised, preclude not later non-Indian use that might interfere with the purposes of that reservation. Contrary to all notions of Western water law that first in time is first in right, we develop a rule that there was a reserved right for Indian tribes. Although unexercised, it exists in law and can come in, it can spring to life at any time that the tribe is capable of putting the water to use. Both cases essentially ignored. Over the next 70 years, the United States embarks through the Bureau of Reclamation on a process of dam building, irrigation projects for non-Indians, directly contrary to Indian reserved rights. And so we've got a collision building. We've got this law that was developed at the turn of the last century, and that says that Indian rights are reserved, they're property rights, they're based on federal law, they supersede conflicting state law. What to do about it? Well, Arizona versus California is a case, it's the next Supreme Court case, 55 years in 1963, that deals with the question of the rights of Indian tribes in California. It's a massive case about the dividing up the Colorado River. Simon Rifkind is the master. He writes a report of nearly 1,000 pages. Probably 150 are devoted to Indian rights. The Supreme Court agrees with Special Master Rifkind that the tribes implicitly reserved enough water when their reservations were established to irrigate all lands capable of sustaining irrigation. And that will be the final measure of their right. The court says, you know, the tribes were settled on desert lands that were hot, scorching sands. Without water, these properties would have been useless. Therefore, we're going to imply a prior right to the reserved waters of the tribe that will supersede any state law rights that exist. Again, okay, now what do we do? Time goes on. Basically, nothing happens until states in the 1970s and early 80s begin to make use of a federal law called the McCarran Amendment that was adopted in the 1950s during one of the dark ages of Indian law, when the federal policy was to terminate tribal existence, to assimilate Indians into the mainstream of society, to remove special protections as they were viewed by some for Indian tribes, and allowed state courts to adjudicate these federally based rights to water. And the statute doesn't say anything about Indian reserved rights, but the Supreme Court, in a series of cases in the early 1980s, holds that the amendment reaches Indian water rights, that state courts can bring those into their own comprehensive proceedings to adjudicate Indian water rights. It's a very confusing situation. It's consistent with the remainder of Indian law. It's anomalous. These are federal rights. Congress has said they can be adjudicated in state court. The Supreme Court says, well, we'll be careful to give a searching review of any state court that doesn't give full credence to the Indian reserved water rights. It's never happened, but they said it in 1983. In the meantime, the Ninth Circuit is the playground for a whole nother set of Indian reserved rights that are making their way through the federal courts, which have concurrent jurisdiction, notwithstanding the McCarran Amendment. And Judge Betty Fletcher, in a crucial opinion called United States Adair, holds that Indian reserved rights are not just reserved for agricultural purposes on a reservation, but also to fulfill fisheries. If a tribe has established a reservation for fisheries purposes as well as agricultural purposes, there might be multiple purposes for a reservation. She writes an opinion that's incredibly confusing. At first, when I first read it, I thought, well, she doesn't know what she's doing. And now the more I think about it, I think it's a thing of beauty. There was a competing doctrine of non-Indian federal reserved rights that very narrowly construed rights reserved for national forests, national parks, and the like. And Justice Rehnquist, in a case called U.S. versus New Mexico, went on and on about, we've got to protect these state law users. Chief Justice Rehnquist, as some call him, the false Westerner from Wisconsin, moved to Arizona. He says it could be, because if we award the Indians any water, it's going to mean a gallon for gallon reduction in water available for non-Indians, and that's bad. But it wasn't clear whether that reasoning applied to Indian water rights or not. And Betty Fletcher writes this opinion in the Adair case about this reservation that has agricultural purposes, but also a fishing tribe. And she said, well, people have argued about whether or not the reserved rights doctrine, it should be narrowly construed, like federal rights should be narrowly construed. And they probably shouldn't, because, and here's why. And then she said, no, but we're going to apply the narrow federal standard. And then she applies the broad Indian standard. And so every time I read that case, it's like, whoa, what's going on here? But what it did was it added to what Phil has called the confusion and incoherence in Indian law. And we talk about that often like it's a bad thing, but it's not. My experience in Indian water rights has been that this incoherence, this confusion, gives rise to the parties to any one of these cases thinking, we don't really want to roll our dice with the courts. Let's do what Phil advocated in 1996. Let's do a bottom-up consequential calculus of what the parties on the ground need. Let's negotiate. Since 1963, the Supreme Court, outside of the McCarran Amendment cases, those procedural cases, accepted review in the only case to be finally adjudicated in a state court out of Wyoming, which resulted in sort of a mixed result for the tribes in the state. The case went up to the Supreme Court to review, well, what should the proper method be to determine what Indian water rights are. And there was tremendous anticipation with the case, and it was held over, and it was wide speculation. It's going to be 5-4. What way? Comes out 4-4. Turns out that Justice O'Connor and her family had a ranch in Arizona that was involved in the Gila River adjudication that was going to be affected by the outcome. She recused herself, and the case comes out 4-4. Then one of my dear friends and colleagues, who's now the dean at the University of Colorado, gets access to Justice Marshall's papers, reviews them, and finds this, what we call the phantom opinion in the Bighorn case. And it would have been the majority opinion that would have completely upset the apple cart in favor of the non-Indians. And I'm thinking, oh my God, David, why did you find it? And then why did you publicize it and append it to your law review article? But again, it hasn't had an adverse effect. It's very confusing. What she did in her usual way was talk about what the standard should be. We're going to send this back to the trial court for additional application of a new standard, not clear what the standard would be. And then she runs through a bunch of these Ninth Circuit holdings and common assumptions about Indian reserved water rights. And she says, We never said that. We never said that. She doesn't say we wouldn't say that, but she says we never said that. And it just completely clouds the area and creates tremendous confusion. What that contributed to since 1990 is we've had 20 Indian reserve water rights settlements work their way through Congress. 2 just passed in the last month when President Obama signed the Omnibus Public Lands Bill. And those were huge settlements, one for the Duck Valley Reservation in Idaho and in Utah, another dealing with the Navajo Nation and providing important water supplies for parts of the reservation that had never been provided water before. And, I think what, Phil's, recognition that, we need to look at these things not through some, doctrinal lens, some abstract set of principles. And, as a young lawyer, I was convinced that the tribes had either an aboriginal right to absolute ownership of the waters based on the Winans theory, which is clearly supportable by the case. As I've gone along, I thought, that is not going to fly. I might think that's the law, and I can craft a beautiful argument, but I know you won't win because of the ideas that Justice Rehnquist set forth about gallon for gallon reduction, be sensitive to non-Indian uses, consider the practical effects of a ruling in a particular fashion. So that whole set of thinking has brought about a shift in the mood. And to think about the work that scholars do in law review articles, I think most practitioners have traditionally thought about that as, let's find something to help me in my litigation. And in the Indian water law context, what the kind of thinking that Phil has advocated has resulted in tremendous benefits to Indian tribes and to their non-Indian neighbors. Remember the quote I read at the start about the fact that the United States is a colonizing nation, and this is an ongoing colonizing experiment, fact on the ground. And what that means is that the United States has got some obligation to deal fairly with Indian people. The canons of construction are rooted in this in some fashion. Phil has written a great deal about that. And Phil, in another article out of the Harvard Law Review in '96, talked about the arguments about these different abstract principles and said, no, what we should do is we should reconceive the field as establishing a framework for negotiation between sovereigns rather than merely for litigation in federal courts. This holds the promise both of greater participation by tribes in the formulation of the federal law that purports to govern them and of the evolution of a more normatively attractive and coherent approach. And that's exactly what's happened in these 20 water rights settlements. Those tribes, were they to litigate their cases to the end, they might win some, they might lose, the Supreme Court might change the doctrine. Even if they win, they end up with a decree that says they're entitled to a certain amount of water that they're not able to get out of the river because they don't have the funds for the infrastructure to deliver the water to their communities. It's a huge problem. The approach that Phil advocates, sovereign to sovereign, is translated into negotiations, and I do a little mediation through my Native American Law Center between Indian tribes, state governments, the federal governments, and local governments. And everyone, the feds don't like it, when I was working for the federal government, I kind of liked it, although I had to pretend that I didn't. Everybody points their finger at the federal government and said, you have a lot to do with the problems that we're experiencing now with respect to competition for water, and the United States should play a major financial role in ensuring that not only that the Indians get water that they're entitled to, but that also that they can put it to use, and also to do something to ameliorate any harm that comes to the neighboring non-Indian communities. And that's been the model of these Indian water rights settlements that have passed Congress. Two already in the Obama administration, 5 more in the queue, based exactly on this model of, let's not use these abstract principles to throw stones at each other in litigation. Let's acknowledge legal theories on either side, practicalities of litigation, the way that the Supreme Court is composed gives tribes caution. At the same time, let's use the opportunity of these adjudications to serve as a vehicle for negotiations for practical solutions that not only provide water for consumptive uses, but that also can provide tremendous benefits in terms of Endangered Species Act, compliance, ecosystem restoration, and most importantly, I think going forward, the ability to flexibly deal with shortages that are bound to occur at different times of the year as a result of climate change and a changing hydrograph. So again, I think that it's just a tribute to Phil that he's writing this in '96, and it's exactly the pattern that's been followed consistently from that point forward in these Indian water rights settlements. And it really, I don't know, Phil, if you knew it at the time, but you described the process that is in practice, the way that Indian water rights are settled and that they will be settled in the future. It's a good model. It makes sense, and it's something that we're going to have to consider transporting into all other areas of federal Indian law. I think my time is up. It says here to close with a pithy, humorous comment. And thank you.
That was well done.
Bethany Berger.
So I guess that can't be my pithy, humorous comment. So Phil wrote, and this is with no disrespect to all the other Indian law scholars in the room who have written many of among my favorite articles, but Phil wrote my very favorite article in Federal Indian Law, Marshalling Indian Law Past and Present. It really shaped my thinking, it shaped my scholarship, it's shaped me as a scholar. And that being the case, when I was a new, not even tenure-track professor at the University of Connecticut, and my dean, Nell Newton, said, this draft article you have, why don't you send it to Phil Frickey and see if he'll read it? I thought, no. Deans have to think that what you're writing is worth reading, but not Phil Frickey. But I trusted her. I sent the article to him, and within, I think, some incredibly short time, a week, something that still embarrasses me when I receive other people's drafts, he got back to me with comments on it. And I think many people in this room have had that experience. So I took advantage of that. I sent him my next article, and he actually told me to, it was great to cut half of it out, which made it publishable. And I sent him my next big Indian law article, and he gave me comments, one of which, this part over here is interesting, it needs more development, and so I cut that out, and that's actually part of the basis of what I'm going to talk about today. And this kind of amazing brilliance and generosity many other people have talked about. Bob touched on the fact that somebody that was so well established in constitutional law and legislation, areas that everybody says matter, would turn his attention to federal Indian law, an area that, as he's actually collected the quotes, Supreme Court justices don't think matter. A lot of people in academia don't think matter a whole lot. I actually just spoke to the clerk for a justice on what we describe as the first case in the modern era of federal Indian law. He said, yeah, we all thought that was a nothing case. So for Phil to turn his attention to that area really means a lot, and the way he turned his attention to it also means a lot. A lot of people in other areas will dip a toe into Indian law and say, you know, it's kind of messed up, but I've got it all figured out. Phil really fully immersed himself in it, really got it, and said both, you can't figure it all out, but also really provided stuff that's been a guiding light for all of us in this field. And just to turn back to the generosity point to junior scholars, I hadn't realized that Frank was one of the junior scholars that he had mentored, and that his mentorship has led to Frank writing what's my favorite book in federal Indian law, so that's huge here. I want to acknowledge some of the other people in the room like Angela Riley and Kevin Washburn, who in addition to all of us on this panel, he has been incredibly generous to. When I think Jillian Lester, who's also visiting at Harvard this year, when she noticed that I was on a casebook with Phil, said, oh, you're on a casebook with Phil Frickey, and you know, who are the other authors? And I said, you know, these are the other authors. We're much more junior. I think I got tenure in the month before the casebook was published. But he's so generous to junior Indian law scholars. And she said, no, he's like that to everybody. So just how he can give us so much of his time and give so much of his time to the wonderful scholarship is just amazing. And the scholarship, it's normative, but a lot of Indian law scholarship is normative, and it's normative in a distinctive way. It's normative in that it recognizes there are norms on both sides. There are non-Indian groups and communities have norms that come up against the norms of Indian tribes and their communities. And so it once acknowledges that pragmatically, but also points out if those norms of constitutionalism and consent are built on top of a reality of colonialism and consentless deprivation, how do we bring those norms together? How do we balance those out? It's also clearly deeply contextual, but it's textual in a way that Indian law scholarship is but needs more of. I mean, I guess you don't get to be one of the 5 best law students in the country without really brilliantly reading and assimilating texts and putting them together. So rather than taking pieces out, he puts it all together and he says, this is part of what makes him say this is incoherent. He's not accepting the phrase for the whole. And so what I'm going to try to do today is take this textual, normative, contextual approach, combine it with some of my own interests in history and race, and try to apply to something that Phil is an expert in, but I'm not, constitutional law, and particularly to the uneasy relationship between equal protection law and federal Indian law. So if one succumbs to the impulse that Phil calls to mainstream the field, to try to make Indian law make sense from outside Indian law, there appears to be a deep contradiction between equal protection law and federal Indian law. Federal Indian law is fundamentally about special rights treatment of tribes and individuals that are in part defined by descent. Equal protection law seems to be about the invalidation of classifications based on descent. And this conflict's gained new attention in the last few decades, but it's really one that's been noticed since the beginning. In the Reconstruction debates, the Congress debated, what does this mean for Indian tribes and for federal Indian law? Those debates did focus on the citizenship portion of the 14th Amendment, but somewhat relevant to the Equal Protection Clause as well. Perhaps less interestingly, in the original arguments in Brown v. Board of Education, Justice Hugo Black asked the attorneys for the plaintiffs, so does this mean we're going to have to shut down all the Indian schools? Justice Jackson, who was by no means convinced that equal protection did require desegregation, picked up on this, asking repeated questions about it, including throwing in kind of gratuitously that he sometimes wished he had some Indian blood so he could live tax-free as he imagined his Indian neighbors in upstate New York did. And Justice, or future Justice Thurgood Marshall, actually responded to this, that yes, Indian schools were unconstitutional, and he thought they'd be held unconstitutional as soon as the Indians organized and started to protest it. Of course, none of this should be taken as either a normative or a legal understanding of what equal protection means for federal Indian law. As we all know, the Reconstruction debates were often deeply racist, particularly about people who were not formally citizens. So not only the savage and brutish Indians, but the eruption of Chinese, even for one, I think, slightly off Pennsylvania senator, the gangs of gypsies that threatened his state. Similarly, the comments about Indians in the Brown arguments were made in the complete absence of any Indian voices, even though, contra Justice Marshall, future Justice Marshall, Indians at that time actually were becoming more and more organized and were actively fighting for their rights. What's more relevant is what Congress and the courts actually did when they were specifically looking at the Indian situation. So the Reconstruction Congress in 1868 ratified a series of very strong Indian treaties that are still in effect today. In 1871, they ended treaty making, something that some have alleged brings Indian law from a quasi-foreign relationship to a purely domestic status, but then went on to pass more and more specifically Indian legislation. And Justice Black, when he was in 1959 specifically confronted with questions of Indian tribes, held that separate sovereign status had to be maintained, not simply as a matter of precedent, but as a matter of deep justice and norms. Now, there are, of course, some good textual reasons for looking at the application of federal classifications of Indians as something separate under equal protection analysis. These include the specific mention of Indian tribes in the Commerce Clause as a distinct subject for congressional action, the Treaty Clause and the number of treaties written under that. So this was dealt with in 1974 in Morton v. M. Carey, and Carol Goldberg has excellently written about this. As Phil has pointed out, these textual argument or bases, while helpful, do not create a slam dunk in this area. They're more like kind of textual clothespins on which to hang the special relationship between Indian tribes and the federal government. So what I hope to add in this is something of the way the history and the normative underpinnings of the Equal Protection Clause and the distinct historical relationship with American Indians contributes to this picture. So if you think about equal protection, it begins with the innumerable ways that individual African Americans were kept physically integrated, but socially and legally completely inferior. If you look at racism towards American Indians, it hasn't typically worked that way. Instead, it was about groups that were separate and the effort to deny them equal status and, in fact, assimilate their individual members. So while assimilated Indians faced not none, but relatively few purely racial aspects of discrimination, tribes were reconceived not as governments, but as inferior ethnic enclaves, as themselves racial groups, in order to deny them those political rights. So undoing racism against Indians involves recognition of their sovereignty and redress for those historical deprivations of sovereignty, property, culture, and so on. Because of this, applying an individual classification model of equal protection to Indian legislation is precisely counterproductive and backwards. Undoing racism instead involves the recognition of tribes as political groups. And today, however, numerous governmental actions that seek to recognize sovereignty, redress historical discrimination, are attacked as unconstitutional unconstitutional racial classifications. In the paper, I'm going to discuss 3 of these, I think. 1, the Indian Child Welfare Act. 2, the Duro Fix, which provides, reaffirms tribal jurisdiction over non-member Indians in their territory, which should be understood as, according to its history, which Nell was deeply involved in, a multilateral agreement between many tribes and the federal government regarding the status of tribal citizens in tribal, when they commit crimes in tribal territories, but is being attacked as a violation of equal protection. But today I'm just going to talk about one example of this, efforts to recognize some measure of sovereignty in Native Hawaiians and attacks on those as violating equal protection. So Hawaii was once a kingdom that the United States and other nations recognized the sovereignty through numerous treaties until the United States acquiesced in its illegal annexation in 1898. This annexation, along with the decades of attempts of land acquisition and transformation of Hawaiian culture that preceded it, was justified by a deeply racist perception of the Hawaii politics, Hawaii culture, and a belief in Anglo-American culture as necessarily superior. In 2001, however, the Supreme Court invalidated an attempt to give Native Hawaiians more control over the lands still held for their benefit in the state of Hawaii as violating the 15th Amendment. More recently, meaningful debates in Congress about restoring some measure of sovereignty in Native Hawaiians have been attacked and held up as creating discriminatory race-based classifications. Under a proper understanding of racism and equal protection as it applies to Indians, I think this is precisely upside down. It was the deprivation of sovereignty that was based in race and that transformed Native Hawaiians from a sovereign people into a racial group. The current debates in Congress are an effort to not reverse that, because Native Hawaiians are not going to get more sovereignty than the kind of pale shadow of quasi-sovereignty that other Native groups have in this country, but at least to partially redress that. A similar analysis could be made of challenges to federal Indian law and a number of other grounds. I shouldn't be understood to suggest that all places where tribes are treated differently from other sovereigns or from other tribes need to be subject to strict scrutiny as under the Equal Protection Clause. Sovereigns, even less than individuals, much less than individuals, are unlikely to be similarly situated in a way that justifies that kind of strict scrutiny. But I think that we need to bring a contextual understanding of the historical relationship between tribes and the federal government and non-Indian groups into our understanding of the text of the Equal Protection Clause and the Constitution. Now, in trying to do this, I've been reading more of Phil's work, and frankly, it's a little intimidating. Could almost like shut you down to say, oh, this is the standard I'm supposed to be measuring up to. But I'm going to try in the future not to be intimidated but instead to continue to be inspired and supported, as I have been, by Phil's support, friendship, and scholarship. So thank you so much.
Sarah? So I have some slides. Let me see if I can get them up. All right, well, thanks. I want to thank Dean Edley and Boltall and Phil, but there'll be a lot more of that thinking going on throughout the talk and later. I also, like Bethany, want to acknowledge my fellow Indian law scholars here and say that it is really purely accident, frankly, that at least I, not Bob and Bethany, who deserve to be there, but I'm up here with on the panel as opposed to anyone else because of the breadth of Phil's mentorship in the field, the enormous respect that everyone in the field has for him, and the wide and well-deserved influence. And I actually tried to get Dan Farber to have 2 or maybe 3 Indian law panels, or frankly a whole Indian law day for Phil, but he shut me down on that. So it is such a pleasure to meet Phil's family. I'm just so thrilled to be able to be here and get a little more context about Phil. All right, so my talk, what's not the matter with Kansas? And being from a state that's also somewhat beleaguered, New Jersey, I'm sympathetic to sort of the unfair reputation that Kansas has gotten. And there are a lot of things that are not the matter with Kansas. For instance, the Garden of Eden Museum, has anyone been to this? Yeah. It is really, really great, and you should go. It's this limestone sculpture house and museum constructed by J.P. Dinsmore, a Civil War veteran and member of the free thinker movement, who moved to Kansas to farm and then retired and did this sort of wild and somewhat Gothic limestone thing, a monument sculpture thing. Kansas also boasts the first Pizza Hut. And the original building is still there on the Wichita State campus. And I could go on and on because there are actually a lot of really very cool things about Kansas. Its history of abolitionism, the John Brown Museum is in Kansas, and some of the bloodiest pre-Civil War skirmishes, of course, were fought in bloody Kansas. But there are 2 really excellent things about Kansas that are somewhat more relevant to this symposium. First, Phil Frickey, one of the best scholars and mentors in the field of American Indian law, was born and raised there. Second, Kansas can rightly boast about the Kansas Historical Society, and more on that later. My first encounter with Phil was through his writing. I was living in Tuba City, Arizona, on the Navajo Nation, and working for DNA People's Legal Services. Is the dean still here? Yeah. You might want to put this, it might make your US news go down a little bit, but so that's approximately where I lived in Tuba City. I was giving myself a crash course in American Indian law because Berkeley, where I went to law school, didn't offer a course on a regular basis back then. So I was reading Indian law articles by the propane light of my hogan in the evening, and hoping that my clients and coworkers wouldn't notice that I didn't know anything about the field. One of the first articles I read, and this was interesting, and Bethany and I did not coordinate this, was the Marshalling Past and Present piece. And the piece really resonated with me. It outlined a way of thinking about the foundational cases in Indian law that did not require either divorcing the racist assumptions about the discovery doctrine from the holdings or discarding the cases altogether. The fact that it was Chief Justice Marshall's approach that made all the difference, rather than that the cases generated some core of unassailable principles, made sense to me in a way that much of the other scholarship didn't. And from then on, I was hooked on Frickey. So it sounds like Frickey's a lot of things now an addiction, too. So what I want to do in the time allowed is to trace the development of Phil's Indian law scholarship describe the value he's added to the field, and highlight some recurring themes. As I see it, Phil's work has the following trajectory. It starts from the perspective of an insightful, if perplexed outsider, kind of looking at the field like, what what is this? And culminates with Phil's recent work encouraging and instigating a new and improved realism in Indian law scholarship with the view of a wise and prodding elder. Along the way, Phil has provided clear-eyed descriptions, nuanced normative prescriptions, and occasional bracing, yet always tactful and kind criticism, both of judges and scholars. So borrowing some of the labels that are generally applied in our field as outlining the phases of U.S. tribal relations, that's how I've organized. And I've taken some liberties, and not every era is represented. But I'm going to go through his work. So first, Phil's discovery phase. In his first Indian law article, published in 1990, Phil canvasses recent Indian law cases and concludes that the predominant scholarly view of Indian law, foundationalism, which a couple of us have mentioned, is really not capturing what's going on in the field. The foundationalists, and some of my dear friends, colleagues, and mentors are in this camp, argue that Indian law is best seen as a set of core principles first announced by Chief Justice Marshall and then coalesced at mid-20th century by Felix Cohen in his famous treatise. And the principles, in short, are that Congress has plenary congressional power over Indian affairs, that tribes retain inherent tribal sovereignty, not explicitly divested, and the canons of interpretation requiring the court to construe Indian treaties and legislation for the benefit of the tribe. So those core principles. And the trouble is that by 1990, the court was abandoning these principles in certain kinds of cases, particularly those involving tribal jurisdiction over non-Indians, and also those involving state authority in Indian country. And also, even in the cases where tribes weren't losing, and there were still some in 1990, this is no longer the case, also apparently relying on other factors. So the canons and the principles just weren't explaining things. And Phil's big message in this piece is that it was neither credible to hew to a pristine, coherent view of federal Indian law, nor efficacious. The court was not listening to the foundational arguments, and even if it were, from a scholarly perspective, foundationalism is unsatisfying, even anachronistic, veering toward an odd and unconvincing formalism, and depicting judging as a mechanistic process divorced from context and contemporary values. Instead, Phil offers a dynamic account, and we've heard this recurring theme throughout the day, of the field, proposing that certain key background values are doing a lot of the work. Phil also, in this piece, touches on themes that will recur and become more developed in later work. One of them is the important revitalizing role of critical scholarship in the field. Another is the emerging significance of international norms with respect to respect for indigenous peoples. And finally, one that emerges very prominently in Phil's later work is the tension, and Bethany touched on this, the tension between the right of American Indian tribes to be apart from our constitutional order, a right which is embodied and protected by the sovereign-to-sovereign relationship at the heart of federal Indian law. That in tension with a seemingly ineluctable pull of mainstream constitutional and public law values. And as Phil puts it in his conclusion to this piece, as this century draws to a close, federal Indian law occupies a place of renewed, if not unprecedented, importance, yet the Supreme Court's performance has frequently been disappointing. Foundationalist approaches have proved too hollow or abstract to accommodate our colonial heritage with the human values of the late 20th century. I read this article shortly after I came to Boulder and started teaching, and was trying desperately to get caught up on the scholarship in the field. And just as the marshaling past and present piece instantly resonated, so did this. As a practitioner who had learned the field by working in Indian country, the idea that context and values were doing the work rather than dry concepts made a great deal of sense. And as a new but always skeptical scholar, the idea that Indian law, or any field of law, was not conceptually tidy, nor capable of being rolled out like an elegant mathematical proof, was just plain honest. So then in Phil's treaty period, he pursues a thread from the California piece in depth and this is the Marshalling Past and Present article in the Harvard Law Review, the idea that Chief Justice Marshall in his Indian law trilogy did more than state a formula. Rather, the key thing he did was adopt an interpretive stance towards the constitutive documents of the U.S. tribal relationship. And this is his summing up the piece. He wrote, "The most important result of a revival of Chief Justice Marshall's legacy would be that judges would be compelled to view Indian law afresh in today's context. The issues would be structural, involving conflicts among sovereigns and not contests between sovereigns and disadvantaged groups who seek judicial solicitude hat in hand. The spirit of the structural constitutive approach would force judges to do the hard work exemplified by Marshall in Worcester, to challenge rather than accept blindly assumptions rooted in colonialism, of which there are many today." So then in Phil's removal period, it has a very different resonance than the actual removal period. He wrote 2 articles suggesting that Indian law should be removed from the domain of ordinary domestic litigation. The first was a commentary in the Harvard Law Review, and Bob talked about this a great deal, so I won't belabor it, but the point of it was that the field of negotiation might well prove more fruitful for bringing Indian law context, the life of Indian law, into Indian law than domestic litigation. And then the second piece during this period was one of my favorite pieces, and I remember Phil told me once it was the least cited, the Minnesota Law Review piece on domesticating Indian law, in which Phil suggests that Indian law should, in this sense, remove back to its international roots, looking to international norms to domesticate the harsher aspects of the colonialist instincts of federal Indian law. And I wonder if it's, in some ways, it's the least cited piece because it's the most prescriptive and I think idealistic, sort of most blatantly normative. And of course, it hasn't come to bear. The Supreme Court has not proved particularly friendly to considering incorporating international norms into its decision-making. And yet, I think in a bigger sense, it's actually pretty prescient. I think problems like global climate change and other international environmental problems are bringing indigenous groups and peoples to the fore at the level of negotiation, and that eventually some of those norms will actually trickle back, maybe that's wildly optimistic, but into our domestic law. Okay, so then Phil's allotment, I lumped some things together here. His assimilation period, really, I should call this. And these are the two pieces, one in Harvard and one in Yale, in which Phil writes about the ways in which the court is slowly erasing Indian law, right, assimilating Indian law as a separate field by harmonizing it with the general public law. The tendency does violence to the unique structural relationship that Phil emphasized in his previous works and in these two as well, between tribes and the federal government, and thereby freezes tribes in the past, foreclosing the possibility that they can evolve as sovereigns to assume functions and responsibilities consonant with their contemporary status. Another problem that Phil identifies in the Supreme Court's cases in these articles during this period is the absence of any defensible guiding principle, either jurisprudential or value-based, for this harmonization. And he identifies this absence after the most searching and respectful review, and I think attempt to find something going on that's explaining the cases other than sort of brute force and colonialism. The tone in these pieces alternates between optimism and despair. Phil is generous to the court, searching diligently for some principled meta approach to the cases, but then he doesn't spare the justices when nothing appears plausible. And he writes, taken as a whole, the judicial method in the diminishment cases might appear to be essentially lawless. In totality, the cases suggest, to adapt an old joke about Congress, no Indian reservation is safe while the Supreme Court is in session. And then later in the same piece, he writes, by refusing to admit that it is implementing a general and repudiated congressional purpose, rather than explicit congressional intent, the court has sought to shift the blame for the erosion of tribal authority to a century-old Congress rather than where it belongs, the current court. By the end of both of these articles, Phil is suggesting that the best the judiciary can do is stay out of it. The damage has been done, and the court lacks the tools, empathy, contextual understanding, a vision of vibrant, contemporary, sovereign tribal government, an adaptable and historically grounded sense of pluralism to stop the hemorrhaging of Indian law. And he writes, in the last analysis, it should be unsurprising that federal Indian law has turned out as confused as it is, for beneath questions about constitutional text, original intent, common law authority, and so on lies a much more fundamental normative confusion regarding the founding of the United States and the development of our constitutional traditions. We have every right to be confused about what we should make of our origins, our evolution, our sense of nationhood, and our creation of a constitutional democracy through colonialism. So then Phil moves to his self-determination period, and I've added a couple of nouns. Self-determination, reconciliation, and revival, and the last two are kind of aspirational, really. So from the despair in the two previous articles, Phil moves to this phase, and I think in some ways it's the most intriguing and engaged period of his scholarship. Throughout all phases of his work, Phil had been, of course, mentoring all of us, students and scholars throughout the country. But in this period, he incorporates that mentoring into his writing and elevates it almost to the level of exhortation. The sense one gets is that Phil has done all he can, trying to describe, explain, justify, and critique the court. He wouldn't put it this way, but I will. No one could do that kind of work better than Phil. And yet, the court remains oblivious. Nothing reaches them. And if Phil can't reach them, then the rest of us sure as heck cannot. So it's time to do something different. In the Connecticut piece, Phil uses Felix Cohn's legal realism as a jumping off point for encouraging a new realism in Indian law. What we need more of is not carping and whining about the court, which I've done more than my share of. What we need more of, me, not Phil, what we need more of is nuanced contextual study of what is actually happening in Indian country that relates to or derives from law. In a speech delivered at the University of Kansas's annual conference on tribal law and institutions, Phil provided some of his own context, describing growing up in the small town of Oberlin, Kansas. It doesn't look like that anymore. He uses his own experiences to highlight that in Oberlin and other small towns, formal law often plays a background role to social and cultural norms. The formal legal institutions are there if you need them, but they do not play a prominent role in most of what actually happens. Despite this, small-town America is not the object of undue suspicion by members of the dominant society. To the contrary, small towns are often idealized for just this sort of legal informality. Tribal communities, however, are subject to a fair amount of suspicion based on the assumption that they operate like small-town America, whether they actually do or not. More often than not, such uninformed assumptions are made by at least 5 and sometimes 9 justices of the Supreme Court. And Phil's point here is that about Oberlin, Kansas, is that scholars should do the important work of describing and assessing how contemporary tribal institutions and communities actually work so that the suspicions are harder to justify. And I want to now use Oberlin for a different but related purpose, to tell not a story about tribal institutions per se, but about the inextricably intertwined fate of American Indian tribes and all the immigrants that followed. I started poking around on the web just to get a little bit of context about Phil's hometown. And the first thing, right, this is all about contextualism, so we need some context about Phil. The first thing that caught my eye is that Oberlin is the home of the last Indian Raid Museum. Phil told me the museum is now called the Decatur County Museum, but the webmaster for Oberlin has not yet caught up to this. And good thing for me, because I never would have looked at the Decatur County Museum for any further stories. And so I stumbled on this incredible story of Indian, non-Indian relations that touched down near Decatur County, Kansas in the autumn of 1878. So what was the last Indian raid? And this is where the second excellent thing about Kansas, the Kansas Historical Society, relevant to this talk, comes in. They have made a lot of documents, original primary source documents, available online. So I started to learn about the last Indian raid from some very early local accounts. And so I'm going to start with those which describe the raid as a couple of days in September, October 1878, when some Indians tore through Kansas, stopping in Decatur County long enough to kill more than several settlers. According to one local paper, the Indian perpetrators were Cheyennes who had broken out of their reservation in Indian Territory, now Oklahoma, and were seeking revenge from an 1875 attack on a group of Indians at Cheyenne Hole in Decatur County. According to this account, quote, they did not do any real damage until they reached Decatur County, where they raided a ranch home and killed 19 people. Another Kansas newspaper, however, estimated the total number of people killed in Kansas as between 75 to 100. And by the way, today the settled version is that it was about 40 non-Indian settlers who were killed. According to that paper, though, the 75 to 100 paper, the Northern Cheyenne, quote, had been moved from their northern hunting grounds against their will and, quote, chafed under the restrictions of the agency, end quote. Yet another version of events from the Kansas Cyclopedia of State History reported that and that's cyclopedia, not encyclopedia, reported that the Cheyennes left the reservation in the Indian Territory because they were, quote, dissatisfied with their rations, end quote. Yet even while these very local accounts were cementing into the last Indian raid story, other histories were being recorded. Wild Hog was one of the Northern Cheyenne men to take part in the raid under the leadership of Dull Knife. And this is a picture of Wild Hog and some of the others after they were arrested and awaiting trial, so subsequent. Also from the Kansas Historical Society. When Wild Hog was imprisoned after surrendering in Fort Robinson, Nebraska, he provided a first-hand account of the Cheyennes' trek through Kansas. He started by describing the close relationship between the Sioux and the Northern Cheyenne, which resulted in their fighting together to save their territory at the Battle of the Little Bighorn. Afterwards, a disaffected and ostracized Northern Cheyenne leader, or non-leader, I guess, Broken Dishes, entered into an agreement with the military, with General Mackenzie, to remove all the Northern Cheyennes to the Indian Territory. And despite the fact that the tribe actually hadn't agreed to this, nonetheless, they were forced to remove to the Indian Territory and join a reservation with the Southern Cheyennes, who they weren't on particularly good terms with at the time. They begged for permission to go back home to the Northern Plains, but were refused. The reservation was small. It was stricken with malaria. 50 children died of measles. And so they, after their permission to return home was refused, they began to plot to leave under the leadership of Dull Knife and another Northern Cheyenne leader, Little Wolf. Wild Hog's account of the violence against the settlers was that it began 40 miles south of Dodge City and was initiated by soldiers who fired shots when the Cheyenne intended only to talk. So here's another amazing thing. This is a picture that Wild Hog drew when he was awaiting trial in Kansas. So widening the lens on this conflict even further, there are several contemporary histories written pretty recently, mostly corroborating Wild Hog's version and also adding even broader scope. According to these histories, the last Indian raid was a tragic encounter that took place in the larger context of the Northern Cheyennes' year-long effort to get back home. As one historian put it, the events constituted a running battle that embarrassed the federal government and military, and that the successful flight of the Northern Cheyennes elicited widespread coverage by the press, leading to severe public criticism of the military. And indeed, despite pleas by Kansas officials to punish the Northern Cheyenne involved, Wild Hog and the others were all acquitted by a Kansas jury for insufficient evidence against them. And I just find that really striking and remarkable fact. Favorable press, along with persistent Northern Cheyenne advocacy, also eventually helped to secure a reservation in Montana for the tribe in 1884. So eventually they got back home, which is where they are today, at the Northern Cheyenne Reservation in Montana. Their homeland and now modern tribal government is still there today. And here's a picture near Lame Deer, which is where the Northern Cheyenne Reservation is. The tribal government consists of a legislative, executive, and judicial branch. There's some members of the Northern Cheyenne Judiciary. And if you look at their website, you can read all about the number of cases that are processed through the tribal court and so forth. Okay, so I am wrapping up. In his exceptionalism article, Phil wrote, "Federal Indian law is rooted in the most basic of propositions about the American constitutional system. It is inescapably the product both of the colonization of the Western Hemisphere by European sovereigns and of the corresponding displacement of indigenous peoples. As Phil has repeatedly emphasized, the way forward that neither erases nor entrenches this brutal origin story is to accord American Indian tribes the institutional sovereign status that they never relinquished, and to confront honestly the contextual and conceptual difficulties of having semi-autonomous nations within our borders. The story of the last Indian raid in Kansas highlights the difficulty, yet also the possibility of getting there. When the story is first told in the local press, it's all about individual wrongdoing that occurred in the span of just a few days. Yet when the lens is widened, and to some extent by simultaneous reporting from other perspectives, including the Cheyenne perspective, it becomes clear that the last Indian raid in Kansas is actually part of a longer, larger national struggle by the Northern Cheyenne to return home. And the striking paradox of this country, the United States, is that despite the many inhumane policies that deprive tribes of their land, livelihood, and culture, other forces have also always been at work. The forces that resulted in the acquittal of Wild Hog and his peers. The forces that responded to the Northern Cheyennes' relentless efforts to get back to the Northern Plains. The forces that today encourage and promote tribal self-governance. Phil is and will continue to be one of those forces. And it makes sense, doesn't it, that this history, his history, and the history of the Northern Cheyenne are intertwined in this way. If there is a reconciliation and revival internal to federal American Indian law, and I, for one, am not holding my breath, but if there is, Phil will have been a major force in that too. So thanks.
Thank you, Sarah. We have about 10 minutes for a few questions from our most patient audience. Don't be shy. Go for it.
As the second panel today kind of puts me to mind of thinking about the Carcieri against Salazar case, where the statutory interpretation, I think in the majority opinion, would be sort of a brutalist form of textualism, and even Justice Stevens' dissent, which I actually looked at the statute in a new way for me, but it was still sort of a textualist response. And of course, in the context, for those who aren't familiar with it, it was a restrictive interpretation of the 1934 Indian Reorganization Act, under which the Secretary of the Interior has long taken land into trust for Indian tribes. And I guess the profession is probably trying to sort out whether it's going to be a one-off case or actually have some continuing impact, but I thought I'd just throw open the question of the court's approach to statutory interpretation in that case, and it's, especially as it relates to the really rejection of the Secretary of the Interior's decades-long interpretation.
To do it.
Exactly.
Well, I think,
Yeah, we want to call Phil up.
let
Yeah, go
me
ahead.
ask Phil. But I think that I knew, as soon as I saw Clarence Thomas's name on the majority opinion, and then read through the first couple of pages and saw that he had pulled out the 1934 dictionary from Webster's to determine what the meaning of now is, that it was going to go badly. But I think this is, and so there have been a lot of debates, and I know the national Indian community is mobilized, through the Supreme Court project, which is a marvelous project, and John Dossett is here to analyze the effects of the opinion, to talk about a legislative fix, and and the lawyer in me says, well, it's a very narrow opinion. I think we can cabinet, and let's spend the next 15 years litigating it through the lower courts and back up to the Supreme Court to see if we're right. But I think, Phil's approach, and maybe we should ask him, I always wanted to be able to call on Phil, is to, this is a perfect example of where you need a sovereign-to-sovereign negotiation, whereas when Nell worked on the Duro fix, that look, the Supreme Court did something that is at odds with federal Indian policy. Whether they were right or not as a matter of statutory construction is beside the point. They did what they did. Now it's a time for the tribes, through their governmental bodies, to negotiate directly with Congress, with their leadership, to fix this problem and assume that there is a problem. Failing that success, at least get the government, the administrative body, the executive branch, to adopt an interpretation of the IRA in light of this opinion that is consistent with modern practice and with the tribes as the constituent sovereigns' desires. So maybe, and I think that's what Phil advocates.
Yeah. Good job.
Phil nodded his head yes.
That does actually bring up something that we had wanted to say and didn't quite get out. In addition to Phil's work in mentoring junior scholars and his work in moving towards what tribes are doing, he's also worked so much with the Tribal Supreme Court Project in trying to create litigation and arguments for the Supreme Court that hopefully in the certiorari process keep those cases out of the Supreme Court, but when they get there, speak in a language that the court can understand. And I mean, I think it's more than simply narrowly textualist. It's kind of out of context, picking up a few words in the text of that statute to reach the result that the court did and said it was following the plain language of the statute. But again, this is not my specialty, but it's not a great sign. If we did not already know, there weren't many great signs about the products of litigation before the Supreme Court.
Well, and let me just interject that I learned about interpretive communities. First, I heard that phrase from Phil and from Bill Eskridge when this Duro case came down that we all talk about, where the court said that tribes had no jurisdiction over non-Indians. I learned so much from the tribal interpretive community because as a constitutional law scholar, I read it. I thought, oh, this isn't a great result, but I see how they got there. I mean, I didn't realize the impact it would have on the day-to-day organization of tribal communities until I went to a whole number of meetings that tribal people called and heard tribal police chiefs and other tribal people get up and say, this is a disaster for us. And everybody came together and this legislation was drafted and passed. And I think something like that is definitely happening here, that community is getting together to educate non-Indians about why this is such a bad case. And I think there'll be a resolution.
Dean Ed.
Who's that gentleman in the back? Chris Sedley.
Thank you all. Listen, there's a chance, a small chance, that I would let Phil step down from the appointments committee if he had a really good book project. So do any of you have an assignment that you want to give Phil?
If he had a really good
A book project.
A book project. I don't know if, Phil's famous for his writing block, as you know, and we'll get together and work with him on this, Chris. How's that?
Seriously, is there something that you
What's the next big project in Indian law, guys?
Well, I know that West Publishing Company said that, they'd be, and we talked on this morning, somebody else, I mean, Bill Eskridge mentioned it, our book hadn't been out for 6 months, and I talked to the guy from West, and I said, how's it going? And I said, when do you ever start thinking about a second edition? He said, I'll send you a contract tomorrow if you want, because of Phil Frickey. There's this analysis of this case of these statutes would be a wonderful piece to work on. Sarah, what else?
Phil doesn't need us to tell him what to write books about.
Yeah, really.
I thought I would use that question as first of all, come on, Dean, you can actually let him off the hook without that. But, we'll have a chat afterwards about, I'll be Phil's representative in the negotiations with the dean on that. But I just thought I'd also mention Phil is not only amazing at calling up, a relative nobody in the field and asking to co-author, he also knows when not to. I actually asked Phil before I had tenure if he was interested in co-authoring a piece that I was working on following up on this whole context thing, looking at how the Navajo Nation actually has responded to federal decisions about their sovereignty, and he so politely and kindly wouldn't. And I didn't know that it was because that would have been really bad, actually, pre-tenure, to have a co-authored piece in the file. I don't know if that was intentional, or maybe Phil just actually didn't want to work with me, which might have been the case, and now I'm just outing him. But I only later realized, like what a huge favor that was.
Just to respond to Chris a little bit, but in the context of what you were saying, Sarah, you were so much closer to the context than I was. See, that was the whole point, was to stimulate people who were better situated than I was to do the kind of work that I thought needed to be done that in many cases wasn't well situated to do. So it was easy to say, you should do it on your own. The Carcieri case, which Rick mentioned, is a tribute to my advocacy skills. I've worked on, and John is probably still here. John, there's John? John Dawson in the back, the General Counsel of the National Congress for American Indians. I don't know how many briefs and other matters I've been involved with John. Certainly not everything the Supreme Court project has done, but a number of things, and I've been very proud of the successes we've had in the Lara case in particular. I worked closely with the lawyers on the amicus brief for the Native American Rights Fund and the National Congress of American Indians and several other matters, and I was working closely on this Carcieri case, and I thought, well, goody, now I have even more of a merger of my statutory interpretation interest and my Indian law interest. This will be really challenging and fun, and the lawyers I worked with at Jenner & Block in DC were terrific lawyers, and we were finished with the brief, and they said, we want to put your name on the front, which I've never done, because I've always thought of myself as consulting with the people who write briefs, not really writing briefs. I don't imagine myself being a brief writer. That's not the value I can add. Providing thoughts and criticisms and things of that nature, yes, but the way the brief should be shaped should be done by people who do that for a living. And they said, oh no, we think it might make a difference. Well, we don't really know if there was a causal impact, but it is one of the most problematic statutory interpretation opinions on its own.
Awful. Yeah.
Leaving the broader debates about textualism aside, it's just a most disappointing opinion, I think, from almost any statutory interpretation perspective. And as Bethany said, it seems to treat the issue completely out of any plausible context. So it is, I think it's probably a one-off,
Yeah.
but I don't know.
On that happy note, I want to thank the panelists, and again thank Dean Edley and the Bolt community for honoring Phil in this very special way. Thanks, everybody.